I'm very happy to turn the program over to today's host, Kathleen McGinnis.
Thank you, Louise. Good morning, everyone. My name is Kathleen McGinnis, and I'm happy to be here with you today. I'm the founder and president of KMM Consulting, a seasoned senior care specialist dedicated to helping individuals and families navigate the complexities of aging in place. I'm also a fourth generation Washingtonian and a member of the board for Friendship Heights Neighbors Network, and also serving as a volunteer commissioner on the Commission on Aging. So I'm delighted to be here with you today to help guide the conversation. I've invited Paula and Lillian to join us and share their expertise on guardianship, legal issues, and mediation. So I'm gonna do Paula's bio first, since she'll be our first speaker. So Paula Gibson is the founder of Gibson Mediation Group, a firm that focuses on family law mediation. Paula is an attorney who mediates divorce and/or elder care cases and helps people navigate conflict by making the uncomfortable conversations comfortable. She especially enjoys helping people plan for their medical, legal, financial, and living situation needs of their aging loved ones. Paula is a neighbor in Chevy Chase Village and for 20 years, and she loves to hike and attend Washington Capitals hockey games. So go Capitals. I wish I'd known you, Paula, when I was having my own aging elder law issues with my brother, who conveniently lived in Paris when I was taking care of our parents. But that was another time. So Lily, who is our second guest in this hour, Lily Hummel maintains her practice focus in elder law, and that is Elville and Associates in Rockville. In elder law, estate planning, estate and trust administration, and special needs planning. Lily counsels individuals and families about eligibility for Medicaid and other programs for seniors and individuals with disabilities, navigating long-term care, establishing and administering special trust. She also represents clients in guardianship matters. A very sticky wicket, to say the least. So, Paula, to everyone in our audience, just a reminder, this program is from 1:30 to 2:30. We may end a little sooner, or we may go over a few minutes, and that's fine. You'll also hear when Lily is finished that we'll stop recording so that people can ask their questions and not be recorded. So, Paula, you ready to take us away?
I am ready to take us away, but before
Okay.
I switch over to my screen share, I first wanted to thank everybody here for allowing us to have this conversation with you today. We really are honored to be a part of your group talk, and we hope that we can provide you with some good information that will make you think about things, and maybe it'll be helpful as well. But also, I did want to do a little bragging about Kathleen before we get going, because I was at a senior networking event yesterday. I shouldn't say senior, we were Aging Well community, and it was loaded with professionals there. And she was the recipient of the 2024 Deborah Levy Humanitarian Award. And so as a result of all of her hard work in the community and helping everybody and being such a great advocate, she won a very prestigious award. So kudos to her. And I wanted you all to know that.
Thank you. That's very sweet of you. Thank you. I was very honored.
Well, it was well deserved. And so now I'm going to try to share my screen, and I'll put it into the big mode here so everyone can see it. I hope you can see that okay?
Yes.
Okay, terrific. Okay, so this is our contact information. We'll have that at the end. So if you had more in-depth questions that you needed to ask any of us, we're happy to connect with you, and we will forward these slides to Kathleen for circulation if you and Louise want to have them circulated. And of course, because we're lawyers, we have to have the disclaimer that this presentation is meant for education. We're not providing any legal advice. It shouldn't be construed that way or a substitute for legal counseling. We're really just here to educate and inform as best as we can, and we're not providing any legal advice. Okay, so that's done. So a lot of people ask, why elder care mediation? Why did you get into this field, Paula? Let me tell you just sort of a quick background that is kind of helpful because in 2018, I was doing divorce mediation in DC Superior Court. I had been a civil litigator and I didn't really love doing that. I liked being the person who helped people solve problems. And so I started doing a lot of mediation cases. And then, the pandemic hits and I decided, why not start my own business and do mediation? But while that's happening, my mother had a medical crisis. And I don't want to get too personal, but she was diagnosed with stage 4 lung cancer. It was a big surprise to the family. And she was the caretaker for my father who had early onset dementia.
Oh.
And so she's on the West Coast. Of course, all the siblings are located all across the United States. And so there was nobody who was the boots on the ground, as you say, with my parents in Los Angeles. So I used my divorce mediation skills to navigate the situation with my family because we all had different opinions about what should happen. There weren't any legal documents in place for my parents. And so I worked with family members and my parents to come up with a plan. And so long story short, I really felt that that was a big signal to me that I needed to share this with other people because people my age and friends that I had in the community were all starting to experience the same things that I was experiencing. And I wanted to help and make it easier for people who are going to face these situations by sharing with them what I have learned to help them mediate difficult situations and to really advocate for the aspect of having a plan to age well. So as you can imagine, this is a very ripe field right now because every day for the next, I think about 20 years, 10,000 baby boomers are turning 65. So as you probably are starting to experience, this creates a lot of economic and societal challenges because it's creating greater healthcare costs, people are living longer, and that requires more medical care for everybody and the ability to pay for that. And so there's a greater need for adults to find other living arrangements as they age in place or they move to assisted living communities. And a lot of times parents do not have their children nearby. And so there's big geographical distances between the parents and the loved ones or the children. And so this can create a lot of conflict because of all the decisions that need to be made when there's a medical situation that happens to one of the loved ones, a parent, and people need to put a plan in place that they hadn't thought about before. So you might be thinking, what is eldercare mediation? A lot of people think, oh, you do meditation. How are your chants? What are your positions? Nope, I don't do that. It's mediation. So it's a lot of conversations, a lot of talking, a lot of communication. It's a way of helping families navigate the conflict that arises when an older adult faces a major life transition. And so it's also a really great opportunity for families to have difficult and sensitive conversations about the next step. And as Lily will get into, it helps you avoid going to court if you can have a lot of these conversations in advance of the crisis. So oftentimes, some of the major life transitions that will cause conflict are things like an unexpected medical diagnosis of a parent. Hello, that was me, which then requires a new need for medical care and assistance. Another major life transition is, as you can imagine, when there's a death of a spouse or a parent. What do we do next? And then the moving of a person, whether they're going to sell the family home, keep the family home, go to a new place, that's a huge transition in life. And that can create conflicts. So, what kinds of conflicts then arise from these major transitions? Well, the biggest one that I experience in my field is the caregiving for an older family member. Who is going to do this? How are they going to do this? When are they going to do this? And again, that geographic distance between family members creates a lot of conflict because the person living close to the aging parent or adult is usually the person who is, closest to handle the situation, but it may not be ideal for that person. Maybe that's the daughter with the young children, or maybe it's the older son who has a disability and he's unable to do that, but he's the closest one. A lot of problems that can happen. And then areas of conflict are the lack of communication. Oftentimes I will be dealing with families where some of the siblings may have not spoken with one another for a couple of years. There are some issues going on. There has been a disconnect over the years. They're estranged. And so they're now having to come together to try to figure out a plan for a parent. And that can be difficult, and it can open up a lot of, family past wounds and family can of worms. And as you can imagine, finances become a big piece of conflict, because then the question is, well, who's going to pay for this, or how is it going to get paid? How do we tap the resources that parents may or may not have? Maybe the older sibling is the one who should pay for things because they make the most money. Lots of things can arise. And I find that a lot of times, a lot of past wounds that people have experienced with their relationships with family members get into the way of being able to develop a plan of action for the parent who needs that support. So by doing mediation, I help people get to a solution, and I get to some of those underlying reasons that may be blocking them from coming up with a plan. I'm not a therapist. I don't provide that type of advice or counseling, but I'm asking a lot of questions. And so I'm different than a regular mediator because I have familiarity with geriatric issues. I know and understand some of the impacts of cognitive challenge, depression, and isolation. I've had 30 plus hours of eldercare mediation where we've had certified dementia planners speak with us about things to look for and some of the issues that arise and some of the potential clients that we'd be having. I have knowledge of elder law aspects. I'm not the detailed person like Lily, but I obviously went to law school, passed the bar exam. And so I know sort of the legal implications of things that need to be decided and things to look out for so that I can properly, have them referred to the right attorney or the right specialist who could help them the best way possible. And in this position as an eldercare mediator, I interface with a lot of people in the aging well community, such as the GROWS network that I was at yesterday with Kathleen. And so you get to know a lot of folks who work with the aging well community. And so it's a great way to have a lot of resources and contacts and connections, and I continuously make them. And so I feel that an eldercare mediator who's out in the trenches working, they are developing those connections, and that can be really a special bonus to the clients that you serve in mediation. And then lastly, an eldercare mediator has experience working with multiple parties who have high levels of emotion. And so a typical eldercare mediation, and I'll get into this in probably the next couple of slides, but I'm dealing with a lot of people and I have to manage those people, and emotions are high. So it's not just a one-on-one counseling session, but it's dealing with a group, and that can be complicated, and you need to be able to navigate that. And so elder mediation is using the same principles of family law mediation to resolve conflict. People need to know that they're coming to this elder care mediation on a voluntary basis. A court is not ordering them to be here, at least with the cases that I have. It's a neutral process. People need to know that I'm not the person who's going to be the judge or the jury who's going to decide what the best outcome is for the family. I'm going to be extracting a lot of information from people to try to get them to answer the questions that need to be addressed to how best to care for the parent or the older loved one. And of course, mediation is always confidential, because should a matter ever get kicked into the courts, the whole idea of mediation is to provide open conversation with the goal to resolve issues, not to try to go into court. But that said, there are aspects of mediation that may not necessarily need to be confidential, because some of that information may be used to talk with other professionals, or perhaps with some of the spouses of the siblings who might be involved in the mediation, but with informed consent, which is something that people and parties would sign about the confidentiality aspects of mediation. I would be able to disclose some of that information as long as they agree to it and it serves the situation best. And so while I'm going through the mediation process, I'm always keeping that antenna up, making sure I'm not seeing any things that could be indicators of perhaps abuse or neglect or safety, because I would be under the obligation to, report that to perhaps Adult Protective Services. I also have to have an antenna up for the capacity of the elder. Is the person that this mediation is about able to participate in the mediation? Does he or she have the capacity to understand what the decisions are that they need to address? Or is it too stressful and they do have capacity, but maybe they shouldn't be a part of the mediation and they agree not to be a part of it because they want the children to resolve the issue and that they are comfortable with going forward with whatever the family decides. And so I'm always keeping my antennas up for referring out to other professionals because I know what my lane is and I stay in it. I am not going to try to pretend to be the therapist. I'm not going to try to pretend to be the expert estate attorney. I know what my job is, and that is to resolve the conflict and then refer to the proper professional who can really do a deeper dive into that exact issue that needs to be addressed. And so in order to do a mediation, I have to have people sign an agreement to mediate. And that deals with the confidentiality aspects that I mentioned earlier. What I do, let me go back to that other slide, is I talk with the family members separately before a meeting. And so if I have a family that wants to retain me to come up with a solution for a parent, I will speak with each decision maker in that family individually so that I understand what are their concerns and what their topics may be that they want to have addressed in a mediation. And that way, the mediation is very focused on the topics that everyone wants to hear about, and it allows each person's voice to be heard. It's really important to have people come to the mediation table, if you will, or the Zoom room, to have their issues addressed. And sometimes some family members may not be comfortable being the person leading that conversation. So I can be that person who is raising the issues that somebody wanted to have addressed. And that way, everyone has an opportunity to have that issue talked about amongst the family. And so I'm entirely neutral. And that's very difficult for some people to understand. They want me to be an advocate for somebody. They want me to look out for the aging parent. Well, I have my antenna towards making sure that what the family is agreeing to sounds like, a sensible plan that would make sense. But that is not my job to make the ultimate decision for the family. It's to get the family to make that decision by asking all those questions and sort of reality checking. Is this going to work? What does that look like? Well, what happens if she lives here? What happens if they move there? And so when you start asking people a lot of questions about what it's going to look like, you start getting answers that may rule out some of those previous ideas that people had, and they're reality tested, and then solutions are reached. And so I'm always understanding that the family interests could be different than the aging adult's interests. And so that's something to always be aware of. And again, be aware of the capacity of the older person. And then, of course, if there are any professionals who are working with the family already and they need to be a part of the mediation, they would be there too. So perhaps an aging care manager might weigh in on about what's the latest situation with the parent in terms of how they're adapting to their new living arrangements at the assisted living community, or what's it like having that caregiver in the home? How is that working or not? And so again, depending on the family situation, people who attend these mediations tend to be the siblings or a close friend who may have some decision-making powers that the parent agreed to, or a caregiver who has some expertise about the medical situation of the older adult. So the family just needs to agree upon who should participate in the mediation. And so again, what happens at these meetings, as Kathleen said in my introduction, I make uncomfortable conversations comfortable. I ask those questions, I reality test, and I really get people to open up and talk about why they think a situation like X should be the solution for mom or dad. And so there's a lot of communication with family members, and sometimes communication gets shut down, and I have to navigate that and work through that and regroup, come back, do this again. But the whole idea is if the parent is able to express their goals, to have them express that to the family, or I read a statement from the parent if they're unable to speak or they're unable to be at that meeting for whatever reason. I get the siblings to state their concerns and their interests. Relevant professionals discuss their perspective. And at the end of the mediation, I draft something called a Memorandum of Understanding. And that is a document that is basically a plan of action for the older adult and for the adult children to follow, if that's the family situation. It's not a binding legal agreement, but what it is, it's a roadmap so that when they go to their next referred professional, they have all the information needed to draft legal documents. So if it sounds like there's a lot of complicated finances, and it seems to me that they would need a trust, and I would say, oh, here are some trust attorneys, that would be terrific. They would get some of their financial documents in order so that they would show up at their attorney's office being organized, and rather than an attorney having to spend lots of time navigating some of the family drama, if you will, it's done. They show up prepared and ready to get to work and to have their attorney explain the legal implications of any decisions that they may have made so that they can go forward and not sort of get down into a knockdown, drag out fight again about issues that were already addressed in the previous mediation. And so this provides a lot of accountability for family members. It also is a cost savings to clients. And it gives them a peace of mind because they actually have a plan. And I'd like to say it's a benefit to the referred professional because they're getting clients who are very organized and they have a plan. And the professionals know what the next steps are to do, and they can advise more in depth about what those issues will be that they need to work on. So a lot of clients, they will leave me with this binder. And it's basically a binder that has some of their medical, legal, and financial documents as part of their plan. And I have a checklist in there on things that should be a part of your plan. Bank account names, passwords, things like that, that are very important to have and that come in handy when you're then having other documents drawn up for you. And those documents would be, an advance directive in Maryland, other legal documents like a trust perhaps, or a will, very important to have. Only 30% of people have them. Financial documents so that there's information that will be helpful for the trust, excuse me, so that everything is addressed in the trust. And, excuse me, all this talking, and any issues about living arrangements that have been decided will also be in that plan. Excuse me. And so elder law mediation supports elder law practices. As I mentioned before, Lily would get a prepared client to her office if they choose her, excuse me, and family concerns are resolved. And it will be Lily's turn now.
Everyone who's in this meeting, please make sure that you put your questions in the chat, and we'll be happy to take any questions from either of our speakers today. Not seeing any questions so far.
Okay, can everybody hear me? Kathleen, can you hear me?
Yes, I can.
Okay, wonderful. All right, well, first, I just wanted to say thank you very much for having me. It's a joy to join you and to collaborate with Paula on this, because I do think there's a very interesting intersection between what I do as a practicing attorney working directly with my clients and what Paula does sort of as an attorney, but in her role as a mediator. So what I'm going to be doing is talking about a couple of things, building off of what Paula discussed in the context of estate planning, specifically during one's life. We're going to talk about the kinds of documents that are useful, but then when I'm working with my clients, what is it I'm looking for? What's the role of the attorney in working with their clients? And what happens if we don't have proper estate planning, at which point we end up talking about guardianship. And so I want to provide some baseline information about guardianship, hopefully so that you can understand if there is conflict, what going through the court system might look like, how Paula's types of services can be involved to help prevent needing court services, or if it is going to go through the adversarial process with someone with my background or a litigator background would be working with you on. When we talk about estate planning, I think it's really helpful to think about a timeline. So there's life and there's post-death planning. And within life, we're also looking at when someone has capacity, meaning they understand what they own, the implications of their decisions, and what their goals are. And over a lifetime, for some of us, we'll see a decline in capacity. And for some people, that results in, at a certain point, a loss of capacity. And we do need to use what I would call their incapacity planning documents. So there's two primary incapacity planning documents that I recommend all adults have. The first is the financial power of attorney, which is the document that is it's appointing a financial agent who can legally step into your shoes. So that's managing the assets that you have, as well as signing contracts, making really important decisions on your behalf regarding your assets in the event that you're alive but not well. Hand in hand with that is your Healthcare Advance Directive. This can be written several different ways. There's different components of it, such as a living will. But for the purposes of what we're doing right now, I'm really focused on the Healthcare Advance Directive, where you're naming a healthcare proxy or a healthcare agent, which is the person who has your authority to speak with the doctors and the healthcare practitioners and make decisions on your behalf in your best interest. Again, all in the context that you're alive, but unable, for some reason, don't have capacity, whether it's temporary or permanent, to make these decisions for yourself. We're not going to be focusing on the during today's discussion on the post-death documents and planning, but I just wanted you to have this slide to have a fuller picture that when people talk about estate planning, they're usually coming in and they're just focused on the will, but good estate planning should really have a much bigger picture than just the will, because we're looking at the different tracks for how assets would be distributed. So through the will, joint assets, designated beneficiaries, and then whether or not you have a trust. But for the purposes of today's conversation, we're focusing on what happens with decisions on your behalf during your lifetime. So I'm going to talk briefly about the two estate planning documents relevant, because the absence of these documents are what leads to the situation of needing your court to consider, your family to consider guardianship. Or if you have estate planning documents, but there is some kind of problem with them, whether they weren't effectively done, or there is some kind of perception that there's undue influence on behalf of people who might stand to gain from the decisions made with these documents. So just really briefly, for these two documents we're talking about, the first is the financial power of attorney. Again, this is where you're appointing a financial agent. In Maryland, we have the statutory form, and if any of you are on the line with DC, DC also has a statutory form. Essentially, policymakers in Maryland have said, if you're a Maryland resident and you have a document that's done in this certain format, then banks and financial institutions in Maryland are supposed to accept it. But it's rather narrow in its scope. So part of estate planning sometimes also includes a broader general durable power of attorney to supplement or wrap around that statutory form. And as part of that, you can consider whether to grant more advanced powers. And I would say this is also part of where there may be conflict later down the line, or upset with family based on whether a person decided to give some of these advanced powers, such as gifting powers or Medicaid planning powers, can have really significant impact on what happens later as a person needs long-term care. And in addition, I would just say that if a person does have a revocable trust, then estate planning is going to make sure that there's harmony between whoever's going to be the trustee in the event you're not able to manage your affairs, who's going to be handling the trust assets, and who's handling the assets that are in your individual name. according to your financial power of attorney. So that's one piece of what we're doing in incapacity planning, is the financial power of attorney. The second piece of what we're doing is this advanced directive for healthcare. It can have a number of different parts. There's no one specific way it has to be written. Generally, these are the different components. It names a healthcare agent. It's describing your preferences regarding life support. It can include post-death preferences, whether you want to be an organ donor, your funeral, burial preferences. And it more generally gives you the opportunity to document your personal values, religious values. You know, you want to have a green burial, you would want certain, you have certain vision for how you would hope that the service, memorial service would be done. So all of this can be part of the advanced directive, but some advanced directives are just 2 pages. It's just naming your healthcare agent, which is fine as well. And I just want to always note, this is not the same as a do not resuscitate order, which in Maryland goes by that acronym MOLST, a medical order for life-sustaining treatment. A MOLST would be done by a medical practitioner, like your nurse practitioner or a doctor, because that's actually a medical order in a cardiac emergency, whether or not to do CPR. So that's a little bit different than a healthcare advanced directive, which is documenting your preferences, where we're not in an acute medical emergency situation, but it's just who's going to have access and the right information when talking with doctors. So I want to talk about a really key consideration in my work. Who is the client? Which is probably something that you, as the client, don't realize I am on high alert about who's the client. So I want to talk about what this concept means, because 1, it's very different than what Paula as the mediator is thinking about in terms of who's the client. And 2, who is the client is a fundamental question for me if there are concerns about someone's estate planning documents, either the absence of, or that there is some kind of serious deficiency with the estate planning documents. One of my primary considerations, the minute we start working together, is who is the client. I have to have that clearly identified and communicated so that we're all on the same page. So just to make this concrete, a very common scenario for me in terms of who comes in my office, adult child calls to make the meeting and they say, you know, mom made me POA. I have concerns about what's going on with her bank account. I want to set up a meeting to talk about it. Right away, I have to understand, who's my client? Is my client mom? And I'm meeting with the daughter in her fiduciary capacity as the financial agent for mom? Or is my client the daughter who has some other concern, or another child who wasn't named as power of attorney, who's concerned about what the power of attorney is doing? So understanding of the assets that are under consideration, who actually owns them, who has the legal right to speak to what happens to those assets, who is benefited or harmed if something undesirable happens to those assets. So I really have to get to the bottom of helping the family understand, who is the client, who am I actually working for, who do I owe a duty of confidentiality to? Does my client have capacity? So sometimes I'll have adult children call me and say they have concerns about mom. Can they come have a meeting about it? And I say, okay, does mom know that you've called a lawyer? Would mom understand? Would mom want to be a part of that conversation? Because if you're calling me and you're concerned that mom is spending money on things you don't want her to be, am I representing you in your interest as what is mom doing with your future inheritance? Or am I representing you in your capacity as the agent on mom's behalf, and you're concerned that she's being taken advantage of or is in an unsafe situation? So my counsel is very different depending on who it is I'm working with. So that's something that I really have to be very, very clear on, and sometimes have to have difficult conversations with families because interests aren't aligned. And so I cannot facilitate a full family meeting. I may need to refer them to Paula when there's discord to have that full family meeting. The other thing I would just say that comes up a lot and can certainly come up when we're talking about potential guardianship, I have to have my antenna up when an elderly client comes in. They want their adult child to be in the meeting. So they say to me, no, I want my child in the meeting. You know, my other child who doesn't agree with what I'm doing, I don't want in the meeting. Okay, well, maybe there's no actual undue influence of the adult child in the room, but to that child being excluded, there very well is going to be a perception of undue influence. There's going to be a presumption that the person in the meeting is trying to steer the boat. Even if I see that's not what's happening, the mere perception is a problem and could jeopardize the validity of the estate planning documents that I'm doing with someone. So those are the kinds of things clients should be aware of, that a good estate planning and elder law attorney is looking out for when they start a new working relationship with a person or with a family. So then moving into, okay, you know, we've talked about what is estate planning. What if there's no plan? So I'm not going to go through all of this, but if there's no plan, we really lose control. And we lose our ability, you lose your ability to make sure that your values are going to be upheld, your goals are going to be met. Because if a person either doesn't do a financial power of attorney or an advance directive, or it's something about it is insufficient or deficient, or there's a perception that there is a problem with it, then we may be left with no alternative but to go through the guardianship process. So I'm going to talk a little bit briefly about what is guardianship. It's a court process. Okay, so it's litigation. This is adversarial. There are due process concerns. So first of all, I, as the attorney, have to be crystal clear on who I represent because this is adversarial. Do I represent one of the children? Do I represent the well spouse? The person who's allegedly disabled, who doesn't have their estate planning documents done. So no one has authority to speak with the bank, to speak with the doctor, to speak with the nursing home, to make some of the hard decisions. That alleged disabled person is going to be appointed counsel, and that attorney is going to represent them and their interests alone. The next of kin is entitled to notice, and they're entitled to participate in the process. We don't get to cut the next of kin as defined by the state of Maryland out of the process, because guardianship is a very serious endeavor. We're going to the court for a declaration that someone no longer has capacity to take care of themselves, and another adult should be appointed to make those important decisions for them. I'd also just point out this is where the roles of Paula and I completely diverge. Because it's adversarial, as an attorney, I am hired to represent one party in guardianship. Whereas when there's a disagreement about, for example, as Paula said, one of the most common disagreements is caretaking, who would be the guardian? Rather than having very expensive and ugly litigation among family about who would be the guardian, perhaps a mediator could be involved. The attorney might represent one of the parties, but it's the mediator that is working with the parties outside of the court system to try to come to an agreement, so that when the court the judge hears the petition and the evidence, there's no disagreement. There's already a family consensus about who's going to be the guardian. Just to provide some quick background on guardianship, there's two types in Maryland. One type is guardian of person, which very loosely speaking, you could somewhat equate to the equivalent of what the healthcare advance directive that healthcare agent has authority to do. This is when a person lacks sufficient understanding or capacity to effectively communicate about personal decisions, their physical well-being, where they're going to live, their medical decisions. That's guardianship of person. And guardianship of property is when someone cannot effectively manage their property. And so that's when the court deems that someone lacks that capacity and another person is going to manage the bank accounts, the house, whatever property the person has. At a very high level, like I said, this is a court process. We have to get 2 certificates done by healthcare practitioners to serve as the medical evidence that the person lacks capacity. If there was estate planning documents done, we have to present it to the court and explain why there's some sort of deficiency about those estate planning documents. But more likely we're going the guardianship route because while the person had capacity, they never signed those documents. And now, you know, there's an IRA where we need to take a required minimum distribution. We need to sign a contract for the person to move into senior living. We need to sign contracts for personal care aides. We need to write checks, sell the house. We need to talk to the doctors. All of these decisions, no one has proper authority to make. So this is where the court will review the medical evidence, hear from the next of kin if there's any concerns, and the court appointed counsel for the alleged disabled person, and they're going to make a decision. It's also important to know that this is a process whereby once someone is appointed guardian, it's just going to stay for the remainder of that ward's life, most likely, unless there was just a temporary incidence of incapacity. This is going to be an ongoing guardianship with ongoing annual reporting requirements to the court. So it's a very significant and consequential undertaking. So the last thing I'll say about guardianship to wrap up is our goal is effective estate planning to avoid guardianship, which is, in my experience, devastating to the family. It can be expensive, it can take time, and you are then subject to court oversight. So you're really wrapping the family process up in requiring court approval for otherwise decisions you'd like to make independently. So we're looking for estate planning that is professionally drafted with an attorney that can ensure not only that there's no undue influence, but they've taken careful steps to avoid a perception of undue influence so that no one on the outside can come in and say mother or grandmother or aunt was influenced inappropriately by someone who stands to benefit. So that's part of the role of the attorney, is advising clients to make sure that we have estate planning documents that would withstand scrutiny. We want to revisit them regularly, especially if there's any big life changes. And the last practical tip that I would share is that when you do your estate planning, I strongly urge my clients, it's your responsibility to share your decisions with your family. Because if there's disagreement among those that may want to serve in an agent role or have a say, you're going to set everybody up for the best success if you yourself, while you're able, call that family meeting and explain why you've decided on whatever roles for different family members, so that they understand you made the decision while you had capacity. It was your decision alone, and it really deflates the potential animosity among family members or confusion. So the more you can take on the burden of communicating that proactively rather than sort of keeping it as a closely held decision, the more I think you can prevent challenges for the estate planning document in the event that you don't have capacity in the future. So that would just be my observation for what can help to prevent needing to go to the court in guardianship in the future. So with that, those are my prepared remarks. I think we'll turn off the recording and open it up to questions.